to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes on sports law. And the legal regime, I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Ishale will take it from here.
Thank you, Honorable Chief Justice. Judge Kigen, there are concerns expressed by a section of Kenyans,
yes,
as regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as the Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what
yes.
the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you're successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who apply to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petitions. There are other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important, it's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So, recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, but I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law, and I want to quote what he says: "Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history. I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be,
yes.
How did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail, keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the two drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, okay, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract that you have to have.
You're supposed to do the same without fear, favor, or any kind of pressure or direction. Now, in your view, are there any safeguards against interference with the independence of judges in the current framework that we have? If you have any, you can mention them. And the second limb of my question, where then is the balance between measuring performance and safeguards, if there are any?
The only argument I would make around that issue is I have no doubt in my mind that there is need to measure performance, and there is need to require the judiciary to demonstrate that they have delivered on it. I have no doubt about that. I think it's the question of how you balance the intricacies around it. And I would think the conversation should be more in saying, are the targets placed on the judges and magistrates too onerous to a point where, in consequence, they look more at making determination even where quality could be sacrificed so that you meet targets. So I think the conversation should be more whether the targets have been balanced in a way that it doesn't place pressure to a point of diminishing the quality of the work done. I would think the conversation would be more there than whether or not there is need for performance. And that's where the balance, I think, needs to be placed.
Okay, that's where the balance, but do we have any safeguards in our laws, maybe statutory?
Yes.
Or even constitutional?
Yes.
To protect or to safeguard the independence of the individual judges and judicial officers vis-a-vis measuring their performance?
Yes, the general proposition that they have judicial independence, I think, is, and the fact that judicial independence right is protected in itself, I think, is the countermeasure to ensure that. And then probably a little more on the judges, also the security of tenure, the process of recruitment, and the budget arrangement for the judiciary. All those, I think, give some level of cushion to protect the judicial officers and the judges.
Okay. Thank you, and I wish you well.
Thank you very much.
Thank you, Honorable Chair. Honorable Judge, I know you've been on that seat for too long,
Yes.
but don't worry, we're about to finish. So my session will not take too long. And now, please address us on the tension between judicial independence and judicial accountability, and tell us how the tension is managed at the level of the Supreme Court, where there is no higher court or where there is no further appeal.
Judicial independence and judicial accountability, I think, is probably the conversation we've just had with the previous interviewer, being the need to arrange so that the judiciary is not such that it is a castle, it is a law unto itself, but is accountable to the public. And so, to my mind, it's a question of just balancing that in the quest to ensure that there is delivery of services, pressure is not placed to a point where the quality of work is diminished. But that independence is necessary and accountability is necessary. And to the extent that your question is, the tension is that my view is that they have to coexist. So somehow they have to find a balance, because both of them are necessary to be to the taxpayers. In terms of the Supreme Court, I think the quality of the work done, I should imagine also that they also have policies on targets of what they are supposed to achieve in terms of timelines and things like that. And I think that still takes care of any concerns that they are not accountable to anybody. But importantly, I think they are accountable in terms of the need to present the state of the judiciary, the need to make presentations to Parliament, the need to justify budgets, and also the public, the access of the public to see their performance is a countermeasure that ensures that the Supreme Court delivers on its mandate reasonably, within time, and to the quality.
Okay. How has the Constitution provided for the independence of the judiciary?
So the independence of the judiciary in the Constitution would include issues like what we are going through, the procedure for recruiting judges, that it is open and public, and the evaluation of the competence is merit-based. There is security of tenure. There is separation of the budget for the judiciary. Those ones come to mind immediately.
Okay, thank you. I'm satisfied. I'm satisfied with those.
Thank you.
The final question from me, I have looked at your choice of referees.
Yes.
You're positively and highly recommended by the referees you provided. And indeed, I can say you know people. So now, given this, as a judge of the Supreme Court, if you are to receive a phone call or a message from a senior state officer in regards to a matter that is before the court, how would you go about that situation?
Okay, I would do what the law requires me to do. I would apply the law to the facts, and it doesn't matter what message or call I have received. I would remain faithful to my calling and to my oath of office.
Would you honor that engagement?
No.
Or discussion?
No, I wouldn't.
Okay. Thank you, and I wish you well, Judge.
Thank you too.
Thank you, Honorable Chair, and welcome again, Judge.
Yes.
Yeah, I have two questions for you. Very, very brief. Now, the judiciary is increasingly adapting digital systems such as e-filing, virtual hearings, and automated case management platforms. While these reforms promise efficiency gains, they also raise concerns about digital exclusion, cybersecurity risk, and over-reliance on technology vendors. How should the Supreme Court guide the judiciary in balancing technological modernization with constitutional guarantees of access to justice and data protection, especially for vulnerable and digitally marginalized groups?
Okay, so thank you. I think it's a question of continuously being diligently conscious of the environment we are in, and always looking out to make sure that some segment of the population is not left out. And in that regard, I think the concept contained in the statute is a very useful one, because it endeavors to reach those ones whose access to technology and whose geographical locations may be so far flung off to a point where they might be excluded from the judicial process. So I would think that the Supreme Court, where occasion arises, would also encourage those that kind of enterprise containing the statute, the ADR and the AGS. On the technology, on cybercrime, I think it is also a question of diligence, remaining very vigilant to make sure that the technology deployed are up to date to a point where it doesn't expose the judicial functioning to the risk of cybercrime and hijacking and frustration.
Okay.
Yes.
Now, in circumstances where a constitutionally sound decision is likely to be unpopular and could create or trigger a political backlash, how would you uphold integrity, impartiality, while maintaining the court institutional legitimacy?
Okay, I understand the question, Commissioner, to be what I would do if there is a, what did you?
There's a case before you.
Yes.
And the decision would actually trigger a political backlash. So how would you maintain or even uphold integrity while maintaining the court institutional legitimacy? The decision
Yes.
might likely
I
be
got the question.
unpopular. Yes.
Yes. You could even replace that by saying the LGBTQ case. Okay. My view of it is that it just calls on the judges to make sure that they reflect deeply and profoundly on what the issue is, and make sure that the judgment speaks for itself, to the extent that anybody who is honest about it looks at it and says in good conscience that indeed the output from the reasoning of the judges is what the law says, and it doesn't matter that it is unpopular. What matters is that the law has been applied, and I can think of a number of cases like the LGBTQ case, the issue of CDF. The judiciary had to deal with adverse view, but I think the quality of the judgment, the way the judgment speaks for itself, speaks well for the judiciary, and helps therefore to maintain the integrity of the judiciary and the perpetuation of the judiciary, being faithful to the calling and being diligent in the work.
Okay. Thank you. I wish you all the best.
Thank you very much.
Yes, good afternoon again.
Good afternoon, Vice Chair.
Yes, I know it's quite long, but almost through with it.
Thank you.
Now, on global issues, how does globalization affect constitutional law?
Globalization affect?
How does globalization affect constitutional law?
constitutional law. Yes. Okay, so globalization, thank you for the question. I think globalization affects the constitution in the sense that even when you have the law, the constitution in place, issues of other jurisprudence come in, and you keep needing to cross-reference it to the constitution. And for instance, the case of BBI stands out very prominently on this, that the constitution is there, it has provided for how it is to be on basic structure. And so you can see immediately the globalization is already integrating with the constitution. And so in answer to your question, yes, the globalization affects the constitution, and the function of the judiciary is to be always on lookout and borrow what is possible and reject what is not in tandem with the constitution. And sometimes see the extent to which they can coexist. That would be my answer, Vice Chair.
How can the judiciary benefit from global networking?
I think it would benefit, first of all, in manpower improvement. The network could be such that knowledge or resource input from partners, and I would think of those two as the important outputs, and also the hybrid of the law that comes then from that kind of integration and relationship.
Thank you, Honorable Sija.
Thank you, Chair, Vice Chair.
A microphone, sorry. Thank you very much, Commissioners and Judge. I believe you are very tired by now.
I'm okay, my lady.
But we are about to complete. Just one clarification from you. When we called out for the applications, there was a list of documents you were supposed to provide. We called for these applications. The advertisement was on 13th January, and it was closing on the 17th of February. And we give instructions on how you are to apply and the documents you provide. The list of documents are many. You provided others, except you did not provide a current declaration of income and liabilities as at the making of the application using the prescribed form. What you gave us was the previous declaration you had made for the Court of Appeal, which is dated income for the period 20th January 2025 to 31st December 2025. You are
My
supposed
lady,
to
do I have your
fill in
permission to refer to?
To refer to the...
I have a copy.
Yes, I think that's the one I'm also referring to, the one you filed.
Yes, which page, my lady?
The one I have, show him. Yes, you have seen what I meant, that you are supposed to, when you were making the application, you were supposed to fill in that form for that period when you were applying.
Yes, my lady. I have been shown by the registrar. As you can see, the declaration is dated January 2026, I think, which is the date it was filled. And the status of the assets between the time I made the previous application and the time I made this application, the assets had not changed. And so that is the answer I have for that. Secondly, my lady, is that my understanding of it is that the declaration intervals would be after 2 years, and but the declaration I had already made, I had labored under the impression was adequate to that extent. So those two reasons, my lady, that the assets had not changed, and secondly that it was still within the time of my last declaration.
Yes, you see, this was a requirement for the application, for every applicant.
Yes, my lady.
To complete that form, even though you had completed earlier, you should
Yes.
have just completed and said the assets are the same, completed and followed the instructions as per the advertisement.
Yes, my lady. My understanding is that I'm in compliance, although I stand to be corrected. My understanding is that I'm in compliance to the extent to which to the extent to which I've just explained in the answer I've just given,
Yes.
my lady. Let me not belabor the issue.
Very well.
Thank you.
So I think this brings us to the end of the interview this afternoon. Sorry it has been drawn over the time that we had dedicated, but I think the commissioners who are interested in proving your suitability. So this is the opportunity we give you also to engage us.
Finding me deserving to be shortlisted for the opportunity to appear